All right, good morning, everyone. It is May 9th, 2023, and this is the Law and Policy Committee meeting of the California Fair Political Practices Commission. Please call the roll.
Commissioner Baker?
Here.
Chair Matich?
Present. All right, we'll proceed to item 1. This is public comment for items not on today's agenda. Do we have any public comment? Hearing and seeing none, we'll proceed to item 2, approval of the April 6, 2023 committee minutes. Commissioner Baker, any edits or comments?
No, thank you. We have to approve.
I will second. Is there any public comment on item 2? Hearing and seeing none. Ms. Contreras, would you please call the roll?
Motion passes.
Aye.
Aye.
Here we go.
Motion passes.
All right, moving right along. Item 3. This is proposed regulations relating to the Levine Act, 18438 through 18438.8 and 18705. With us this morning is Senior Commission Counsel Kevin Cornwall. Good morning, Mr. Cornwall.
Good morning, Chair Matich and Commissioner Baker. As you're aware, effective January 1st of this year, SB 1439 most notably amended Section 84308 so that 1, the statute no longer exempts local governmental agencies whose members are directly elected by the voters, and 2, the period in which contributions in excess of $250 are prohibited following a final decision has been extended from 3 months to 12 months. As part of the Commission's ongoing efforts to update its regulations to address the amended version of Section 84308, staff has drafted various regulatory amendments. The proposed regulatory amendments were first presented for pre-notice discussion at the Commission's February meeting. Thereafter, the proposed regulations were revised and presented again at an interested persons meeting held in April. During the IP meeting, staff received significant helpful feedback and has consequently further revised the regulations discussed today. Today, I'd like to briefly discuss each of the proposed regulations before going over some hypothetical scenarios to illustrate how the proposed regulations would or could operate. Please let me know if you have any questions regarding a particular regulation. First, proposed Regulation 18438, titled Application of Government Code Section 84308, would codify the Commission's Kendrick opinion issued last December and specify that Section 84308's amended provisions do not apply to contributions made or received or proceedings participated in prior to January 1st, 2023. In a letter submitted to the February Commission meeting, the League of California Cities expressed concern that the prior proposed language read as a broad amnesty provision for any violation of Section 84308 that occurred prior to January 1st, 2023. Accordingly, staff has updated the proposed language to Regulation 18438 to better reflect the intended application. With respect to Regulation 18438.1, that regulation provides definitions and other provisions relating to officers and agencies under Section 84308. Since presenting this regulation at the February Commission, staff has further revised the regulation and now proposes removing subdivisions A1 and A2 as unnecessary in the wake of Section 84308's expanded scope, reorganizing and restating the exception applying to members of the governor's cabinet, revising the definition of officer of an agency to better capture what staff believes is the intended scope of 84308, and finally, also amending the regulation's definition of constitutional officer to also include the superintendent of public instruction, another elected state office recognized in the California Constitution. With Regulation 18438.2, that regulation pertains to proceedings under Section 84308. Ahead of the February Commission meeting, Cal City suggested that proceeding was not sufficiently defined, and the California Political Attorneys Association also suggested that the regulation did not address what constitutes a license, permit, or other entitlement for use. Staff has also received questions on whether certain contracts qualify as a labor contract, or what is the definition of competitively bid contract for purposes of Section 84308. With that in mind, staff has revised the regulation with the aim of addressing those questions and concerns. Staff also intends to present 3 options for the Commission to consider in defining the term pending as used throughout section 84308. Option 1 would categorize a proceeding as pending for purposes of the statute when it is before the officer for the officer's consideration, or if it is reasonably foreseeable the decision will come before the officer in their decision-making capacity, and the officer knows or has reason to know the application has been filed or the issue is otherwise within the agency's jurisdiction for its determination. Option 2 would more broadly categorize a proceeding as pending when the application has been filed or the issue is otherwise within the jurisdiction of the agency for its determination or action. During the IP meeting, staff received numerous comments highlighting concerns with respect to both options 1 and 2, primarily focused on whether option 1 did not sufficiently protect against pay-to-play practices, or whether option 2 could feasibly be implemented or adhered to. Staff considered these concerns and consequently drafted option 3. Option 3 proposes a context-specific approach to determining whether a proceeding is pending for purposes of section 84308. Essentially, it would apply option 1 to officers and option 2 to parties and participants. In other words, as soon as a party files an application or a person qualifies as a participant in a proceeding, the party and participant are prohibited from contributing to officers who may be involved in the proceeding, even if the decision isn't currently before them. With respect to the officer, however, we would define the proceeding as pending when either the decision is before them or it is reasonably foreseeable the decision will come before them and the officer knows or has reason to know the decision is within the jurisdiction of the agency. Staff believes that this proposed option, option 3, would be more effective than option 1 with respect to limiting pay-to-play practices, in large part by limiting the number of contributions that may be made by parties and participants even before a decision comes before an officer when the party or participant already knows the proceeding is pending. However, option 3 would also be more feasible to implement and adhere to than option 2, as it would recognize the different circumstances in which parties, participants, and officers may reasonably be expected to know about a proceeding. For these reasons, staff recommends the Commission adopt option 3. Regulation 18438.3, it relates to agents in the context of section 84308. Since the February Commission meeting, staff has revised the regulation's definition of agent to further specify that it pertains to individuals who are compensated to represent a party or participant. And after the IP meeting, we further revised it to specify that the communication with the agency be for the purpose of influencing the decision. Staff also proposes adding a new subdivision that would specify certain types of communications that are not made for the purpose of influencing a proceeding. Regulation 18438.4 relates to participants under section 84308. The proposed amendments to the regulation are intended to clarify the type of conduct that constitutes active support or opposition, as that term is used in section 84308A2. Based on feedback received at the February Commission meeting, staff has revised the regulation so that its definition of lobbies in person would encompass direct communications generally, and a person would otherwise act to influence an officer when they communicate in some other manner for the purpose of influencing the decision. Proposed regulation 18438.5 relates to aggregation of contributions. Based on feedback we received at the IP meeting, staff has further revised the proposed regulation to incorporate and reference section 82015.5, which contains the standards for aggregation of contributions generally. Regulation 18438.6, this addresses solicitation, direction, and receipt of contributions. Prior to the February meeting, we received comments expressing uncertainty regarding the scope of the phrase committee controlled by the officer, and whether the commission and whether the regulation applies to office holder accounts. So we've revised the regulation to address that and specify the types of committees the regulation applies to. We are also proposing amending subdivision B's definition of solicit to include scenarios where an officer or candidate directs a candidate to request a contribution to any other candidate, public official, or committee aside from the candidate's own. This would bring the regulation in line with Section 84308B's statutory text, which prohibits an official from accepting, soliciting, directing, or directing contributions exceeding $250 from parties or participants on behalf of any candidate for office or committee. Regulation 18438.7 relates to prohibition and disqualification under Section 84308. Based on the extent of the proposed changes to the current regulatory language, staff proposes repealing and adopting the regulation. Three of the primary concerns staff has heard expressed regarding SB 1439 are uncertainty in one, determining who qualifies as a participant for disqualification purposes; two, understanding an officer's duties regarding determining an individual's potential financial interests; and three, understanding an officer's duties regarding recusal once a disqualifying financial interest has been determined. Staff has proposed amendments to Regulation 18438.7 that aim to address these concerns. Proposed subdivision A aims to clarify that officers must consider all relevant facts known to them at the time of the decision, while stating in a more succinct fashion certain broad types of facts officers should consider. Since the IP meeting, staff has revised proposed subdivision A2 to more clearly establish bright line standards regarding knowledge of certain facts in which an officer would be deemed to have reason to know of a participant's financial interest in a decision. This presumption could be rebutted if the officer is aware of additional facts that amount to clear and convincing evidence the participant does not, in fact, have a financial interest in the decision. Proposed subdivision B would further establish that an officer willfully or knowingly receives a contribution when the officer is aware of certain facts that should prompt them to investigate whether the party or participant, disregard that. Staff intends to present the commission with two decision points in subdivision B. First, whether to include a provision that specifies that an officer without actual knowledge of a contribution from a party or participant with a financial interest does not have reason to know of a contribution based solely on the fact that the contribution was reported under the Act's reporting provisions. Second, the commission can consider whether to include a provision that specifies an officer does have reason to know of a contribution previously reported under the Act's reporting provisions if the party is included in the agenda for the public meeting. These provisions are not mutually exclusive, and the commission could consider adopting one or both of them. Staff recommends adopting both. Proposed subdivision C would aim to more clearly establish the standards under which an officer can return a contribution, and proposed subdivision D would establish a standard by which an otherwise disqualified officer can take part in a proceeding prior to returning a contribution under certain conditions. Based on feedback we received at the IP meeting and after additional review and consideration of the statutory text, staff is now proposing that participation be permitted ahead of return of the contribution as long as the return is made within 30 days of the time the officer knew or should have known about the proceeding and the contribution. Regulation 18438.8 relates to disclosure requirements under Section 84308. At the February Commission meeting, staff proposed non-substantive amendments. However, comments we've received prior to and during the meeting, including those made by Cal Cities, highlighted the need to address circumstances where an officer learns of a contribution during rather than prior to a proceeding. Accordingly, staff has amended subdivisions A and B to address those circumstances. And we have also revised the regulation to remove subdivision C and incorporate disclosure requirements into subdivisions A and B. And then lastly, final regulation 18705 permits officials to take part in governmental decisions they would otherwise be disqualified from, where their participation is legally required. The proposed amendment would apply this regulation in the context of section 84308. After the IP meeting, staff revised the proposed language to address a comment made by Cal Cities, pointing out that in instances where an officer becomes aware of a contribution during the middle of the meeting, they may not have the necessary information to provide certain details, such as the specific amount of a contribution. So the proposed revisions would essentially require more basic information, after which the more detailed information could be looked into. And then that concludes my summary of the proposed changes to the regulations. If you have any questions regarding that, or I can go right into a discussion of some hypotheticals.
I had one question on the statute,
Yeah.
and then I'll turn over to Commissioner Baker and kind of go from there. So my question is, when I was going back through 84308 following the most recent amendments by the legislature, I noticed in subdivision C, which is the subdivision that includes both the requirement that a public official who has received a contribution of more than $250 has to state that fact on the record, and then separately, they also would be precluded from participating in that matter unless they bought down the contribution below to 250 or below. And what I noticed was the obligation to disclose applies to parties and any participant, period. But on the recusal portion, it is tied to contributions from a party or from a participant or participant's agents, and I'm quoting, if the officer knows or has reason to know that the participant has a financial interest in the decision. And that language about knowing about a financial interest isn't present in the disclosure portion of subdivision C. Here's why I'm confused. I'm hoping you can help me. When I look at the definition of participant, I read this to mean it is a person who engages actively to support or oppose a decision and who has a financial interest in the decision. So by definition, every participant has a financial interest. So the only people that would be subject to the disclosure requirements are those that the public official already knows have a financial interest. So what is the significance of the language about a public official having to know about the financial interest when it comes to the obligation to recuse from a decision, when that language is not present in the section about disclosing from a participant?
I'm sorry, could you repeat the last portion of your?
Sure, I'm trying to figure out, from our standpoint, as we're interpreting this, and let me just ask it maybe this way, do we view there to be some heightened standard, some additional information that a public official would have to have from our perspective before the recusal requirement comes into play? Or the definition of participant already says that every participant under this statute has a financial interest. So the way I look at it is, if I'm disclosing a contribution from a participant, I automatically already have to know that they have a financial interest, because only people with financial interest qualify to be a participant for disclosure purposes. So do I need any more information for purposes of recusal? Or once I disclose, I have to recuse unless I pay down the contribution? That's really the question.
Yeah, I agree that it is a interesting quirk in the statutory language. I agree, though, that it would simply require that the official disclose when they know or have reason to know of the participant's financial interest in the decision, after which they would be required to recuse, unless they had, unless thereafter they were able to pay down or return the contribution. But the alternative would be requiring the recusal in the context where the officer doesn't necessarily know that they have a financial interest, which I don't think was the legislature's requirement or intent, excuse me.
So every participant that if I'm a council member, if I disclose somebody having given me a contribution as a participant, then I must recuse from that decision unless I've paid down the contribution that I've disclosed from that person below $250.
I understand the distinction you're making. So if I understand correctly, you're saying in the circumstance where an officer does not necessarily know that someone who has taken part by, say, commenting at a public meeting doesn't necessarily know that they have a financial interest. In the circumstance where they go above and beyond and note that they have received a contribution from this person, I don't think that the 84308 necessarily requires them to recuse themselves based just on that disclosure. Like I said, I think that would be going beyond what 84308 requires. If after that point they learn additional facts that indicate that the participant does in fact have a financial interest in the decision, at that point, I think that 84308 and the regulations would require that they recuse themselves from the remainder of the proceeding.
Well, I appreciate what you're trying to do, but the statute doesn't require disclosure of contributions from anybody by the public official other than participants and parties. And we can set parties aside because it's easy to understand who that is. That's the person who's filed the application. But participants have a legal definition for purposes of compliance with this statute, and that legal definition requires a financial interest. And so if a public official is disclosing somebody under the guise of they are a participant, that public official is stating that they have met both the criteria to be a participant under the statute, which includes having a financial interest. And so at that point, they are on record as saying this person is a participant, therefore they have a financial interest, therefore I must recuse unless I pay down the contribution. That's how I'm reading the statute, and I'm wondering how we wouldn't read it that same way.
So sorry, yes, I guess I misunderstood what you were saying in terms of the officer's classification of the individual in terms of whether they're considering them a participant in the legal sense under 84308 versus someone who has simply made a comment at a public meeting. But I do agree in the instance where the officer both knows of the contribution and believes that the participant has a financial interest in the decision, then they would be required to both disclose and recuse. Yeah.
All right. And at least as I understand it, because the legislature has defined participant in that way, where that person has to have a financial interest, that to me suggests an implied duty on the part of the public official before they disclose somebody as a participant to have made some kind of determination that they have a financial interest. Otherwise, they're not a participant under the statute, are they?
Correct.
Commissioner Baker?
Thank you. And I want to pick up on this thought and then I'll maybe go to some others that are a little bit more broad and less specific. I think it's a practical matter on that last point. I'm not sure I see it as a duty, but there is a duty for the official to have done, as you said, to have reached a conclusion. The person has a financial interest, or I think that's what you just said in your last point. I don't know that I can jump to that duty because I also think there's a practical implication here is that an official is not going to do necessarily that legal analysis of having a duty unless we say it. They are more likely to just be cautious. At least right now, in the immediate aftermath, we may see a lot of officials. They're not sure, but they don't want to get in trouble, so they're likely to, perhaps be overly cautious, or because there's some fuzziness about whether there's a duty, they may miss it and get a complaint against them. So, for me, I'm looking at how this will practically play out, and how much we can reach a conclusion that A, they're going to realize there is a duty, and B, they would necessarily, when they identify someone, they have reached that conclusion to a certainty. I think they're going to be much more cautious and And even if they haven't reached it, they're going to protect themselves. So I throw that part out there. I'm curious if chairs in colloquy, your thoughts on that, because I'm just thinking of the practical day-to-day way this will be applied.
From a practical standpoint, I don't disagree at all. I think this is a very difficult statute to implement in what I would consider to be a practical way. And for example, without having some obligation on the part of the public official staff to ferret out this information for the benefit of the public official, it's going to be harder. Without having an obligation to have participants state this information on the record, it makes it difficult. Setting all of that aside, that's not our role here. The legislature made this policy determination, and our job is to stick with the language in the statute. And I cannot help but note that the definition of a participant, the only people that are supposed to be disclosed are parties and participants. And the legislature chose to define a participant as somebody with a financial interest. So I don't know how a public official discloses somebody as a participant without also inherently knowing that information. However they acquired that knowledge, it is what it is. Once they say it's a participant, that's what everybody can assume they must mean, because that is the definition in the law. And the problem with being over-inclusive is the whole point here, the whole purpose of the exercise is to narrowly target those people who have both contributed and have a financial interest in the decision. And if we just, in abundance of caution, disclose 100 people when there's only 3 that meet those requirements, we have now obscured transparency, which I don't think was the intent of the legislature here. And so we are stuck, and that's part of the reason I was asking the question after I thought about this a little bit more, because I do think the legal definition of a participant involves knowing that they have a financial interest.
And I love grounding us in the language of the statute, and completely agree that it has a very specific definition. I guess I'm not jumping to the conclusion that there will be a duty. Maybe I got mixed up in the language you used as duty, that the official will have undertaken a duty before he or she makes that disclosure to confirm that, as opposed to they are going to read it broadly. And so I'm hesitant to put in language that we are identifying a duty here that comes from the fact that they announce someone has a financial interest and they're a participant to whom this applies. I wouldn't put it both ways. So,
well, I guess let me ask you this question: under subdivision C, is it our view that a public official has a duty to disclose participants within the meaning of 84308 who have made contributions of $250 or more?
I'm sorry, can you repeat that?
Sure. Under subdivision C, do public officials have a duty to disclose contributions from participants within the meaning of 84308 on the record of a proceeding?
Yes.
So they have the duty to disclose. And the thing they're disclosing requires a determination about whether the person meets that standard. So I don't see any other way of interpreting this other than that there must be some duty on the public official to ascertain that knowledge before making the disclosure. Otherwise, the disclosure is rendered somewhat meaningless. Now, again, I'm sympathetic to the significant practical difficulties that are presented by this law, this new law. And we should be reasonable. But I wanted to talk about that on the record because I think it's an example of how the statute, in seeking to achieve its goals, is a little bit, it's hard. It's just hard to see practically how this is always going to work. So
I would just add to that I think the implied duty, or the duty to make that determination is also implied by the fact that it's not just that the officer knows, but also that the officer has reason to know. So I mean, I do think that there is an implied determination prior to disclosure.
Yep. All right. Thank you.
Thank you. I'm going to go back to the big opening of the funnel. This question probably seems so trivial now that we've gotten to the nitty gritty, and we will get to more of it. It had to do with I appreciated in the staff memo and in your presentation specific mention of Cal Cities and some other individuals and associations that weighed in on points that was very helpful. It did prompt me to ask if in the interested person meeting and in our other outreach beyond Cal Cities, if there, because there's so many other levels of electeds to whom this will apply that are not city council members, CSAC and county supervisors, elected water agencies, school boards, whose decisions might be about boundaries, about whose kids are going to go to which school, and raise questions about what's a financial impact. Was there participation at the IP or outreach initiative taking on our own part to School Boards Association? There's various water agencies of elected officials. You can pick which ones it is. And CSAC. I'm just identifying a few because their types of decisions that they make are different than Cal Cities, and realize they could have been covered by many other of the representatives who participated. Can you comment on those 2 points?
Yeah. First, I didn't reach out to specific organizations like the ones that you've identified beyond whoever we sent out notice to via our listservs and that sort of thing. The people or the organizations that participated in the February meeting, the IP meeting, and that we've been in contact with are generally the broader, more statewide organizations. But with respect to the types of organizations that you're identifying, I think that there is perhaps, I don't want to assume what their concerns may or not be, but I think that it's closer. The version of 84308 that is in place now under SB 1439 is much closer to the version prior to SB 1439 than it is for city council members or county council members in the instance where the say the board is an appointed member who was already subject to 84308 under the prior version of the statute. I know that there are obviously other boards and instances in which those people are elected at the local level, but we just haven't heard from them.
Yeah, the obligation is on their advocates and their members to take some initiative with us, be in notification and participate. So I wouldn't put it all on us. But given and I know you've done significant outreach and engagement with interested parties, and I'm grateful for it. But given the very complex part of this, if there is time, I would see if there's a way to reach out to CSAC, School Boards Association. I can't remember the name of the water agencies, because, and if they don't, participate in the next week, and then it's on them. We've gone the extra mile. For me, it is because the nature of their elected positions and the decisions that they make are a little bit different. As I mentioned on the school boundary, for example, or maybe there's water rates or something. I'm trying to think of an example that are very much subject to political contributions and elections, and I'd want to make sure that we can try to head it off at the pass by getting it before these are adopted. Okay. So that was my big funnel at the opening part, knowing that we've done a lot of extensive participation. My next ones, most of mine go to either fact patterns and scenarios or particular provisions. It's possible that my questions, I could narrow some down if we go through a few of the fact patterns that I think have already been identified, and then I'll circle back if we haven't already covered it.
Okay. Could we pull up the slide? Okay, so I will just read it for the sake of everyone participating in the meeting. So on January 2nd, 2023, Dave, a developer, files an application for a permit from the city of Sacramento to allow him to convert an unoccupied office building across from the Golden One Center into affordable housing units. Under the city's rules, the application must first go to the City Planning Commission for approval before the City Council votes on it. The city uses the state default local contribution limit of $5,500 per election for candidates for city council and mayor. In May 2022, Dave contributed $5,500 to city council member Hahn. On January 3rd, 2023, he contributed to city council member West. On January 5th, 2023, he contributed $5,500 to Planning Commissioner Nakano, who has formed a committee for the purposes of seeking election to the office of Sacramento Mayor in 2024.
I see what you did there.
Uh-huh.
How, you got it. It's better than green acre and red acre in property class. So thank you.
So this first sort of introductory slide raises a couple illustrates a couple points with respect to a couple of the amendments that we've made in regulations 18438 and 18438.2. So first, we see that Dave has made 3 contributions, all of which are over $250. He made one contribution to City Council Member Hahn in May 2022. He made the next to Councilmember West the day after he filed his application in 2023, and he made his third contribution to Commissioner Nakano 3 days after he filed the application. So with respect to Councilmember Hahn, we can essentially just ignore that contribution for purposes of Section 84308 because it was made in 2022, before SB 1439 went into effect, and before Section 84308 applied to her. So under the Kendrick opinion and the proposed Regulation 18438, the contribution doesn't implicate Section 84308. With respect to the contributions made to Councilmember West and Commissioner Nakano, the answer is more complicated. These contributions were made after January 1st, 2023, so the amended version of Section 84308 applies to those contributions. Because Dave made the contributions after he filed the application, the permissibility of the contributions would depend on the definition of pending under Regulation 18438.2 that is adopted by the Commission. Under Option 1, the mere filing of the application would not mean that the proceeding was pending. Rather, the proceeding would be pending once it was before the officer for the officer's consideration, such as being placed on a public meeting agenda for discussion or decision. If the permit application was not yet before the officer for the officer's consideration, then the $5,500 contribution would be permissible. If the permit application was already before the officer, the contribution would have been impermissible for Dave to make and for Commissioner Nakano to receive. In this scenario, the application likely isn't before Commissioner or Councilmember West, given that she's on the City Council, so the contribution would have been permissible for her to receive under Option 1. Under Option 2, the proceeding would have been considered pending as soon as the application was filed. Therefore, the contributions would have been impermissible for Dave to make and for Commissioner Nakano and Councilmember West to receive. Under Option 3, the proceeding would have been considered pending with respect to Dave as soon as he filed the application. Therefore, Dave would have violated Section 84308 by making the $5,500 contribution while the proceeding was pending. However, with respect to Commissioner Nakano, she would not have violated Section 84308 by receiving the contribution if 1, the decision wasn't before her, or 2, she did not have reason to know about the application, or it was not reasonably foreseeable the decision would come before her in her decision-making capacity. The same standard would apply to Councilmember West. We know that the decision isn't before her yet, so she would not have violated Section 84308 by accepting or receiving the contribution unless she had reason to know about the application. Are there any questions about the first slide? Okay. Can we? Okay.
Sorry, I'll wait till we go through all of them because they may be covered again by all of them.
If
I
we
will
could-
pepper you with questions eventually. Thanks.
If we could move to the next slide. So on July 1st, 2023, the Planning Commission meets for the first time to consider Dave's application. Dave testifies at the Planning Commission meeting in support of his application. Jay, who owns a deli adjacent to Golden One Center and within 200 feet of Dave's proposed project, also testifies in support of Dave's application. Jay previously contributed $500 to council members West and Hahn in September 2022, and on January 30th, 2023, Jay made a $500 contribution to Planning Commissioner Nakano's mayoral election committee. Brian, a union certified electrician who made $300 contributions to both Planning Commissioner Nakano and Councilmember West in June 2023, also testifies in support of Dave's project at the Planning Commission meeting, stating, "Approval of this project will provide steady work of many union certified electricians like me. The Planning Commission asks to gather more information about the economic and environmental impact of Dave's proposed project, but does not otherwise vote to approve or deny Dave's application at the July 1st meeting." So I think it's easiest to go through this slide by breaking down the responsibilities with respect to each person. So for Dave, under Regulation 18438.8, which pertains to disclosures, if Dave, or we know that Dave made his contribution after filing his initial application. So under 18438.8, he was required to disclose that contribution within 30 days of making the contribution. With respect to Jay and Brian, they are participants or potential participants, depending on their financial interest in the decision. But Section 84308 does not require that participants disclose their contributions at the meeting. For Commissioner Nakano, under Section 84308C and proposed Regulation 18438.8, she's required to disclose at the meeting, potentially or prior to potentially taking part in the proceeding, the fact that she's received a contribution greater than $250 from Dave within the past 12 months. Under Section 84308C, she is also prohibited from making a decision, participating in the making of a decision, or attempting to use her official position to influence the proceeding if she willfully or knowingly received a contribution exceeding $250 within the preceding 12 months from a party, party's agent, participant, or participant's agent, if she knows or has reason to know that the participant has a financial interest in the proceeding. So this raises a couple of important questions. First, whether she willfully and knowingly received the contributions from Dave, Jay, and Brian. Regulation 18438.7b, under that subsection, she would be considered to have willfully or knowingly received the contribution if she, 1, has actual knowledge of the contribution, 2, if the contribution was disclosed by the party pursuant to 84308E. That's the general disclosure requirement for parties. Or 3, she's aware of other facts establishing reason to know of the contribution. This also gets into 2 optional provisions discussed earlier with 18438.7. First, whether the commission wants to adopt a provision specifying that the fact that a contribution has been reported under the Act's reporting provisions does not by itself establish willful or knowing receipt of a contribution for purposes of Section 84308. In this hypothetical, this would affect whether Commissioner Nakano is deemed to have known about the contributions at the latest on the date they were reported as part of her campaign filings. Second, the commission could consider a provision specifying that an officer does have reason to know about a contribution previously reported by a party in a proceeding noticed on an agenda coming before the board on which the officer serves. So even if Commissioner Nakano was unaware of the contribution she received by Dave beforehand, once the agenda is published specifying Dave's involvement as a party, Commissioner Nakano would be considered to have willingly received, or excuse me, would have been considered to know about the contribution at that time. This would mean that even if the mere reporting of the contribution did not equate to willful or knowing receipt of the contribution for purposes of the Section 84308, she's deemed to have known about the contribution once their involvement in the proceeding has been noticed as part of the meeting agenda. The second major question is whether Commissioner Nakano knows or has reason to know that Jay and Brian have financial interests in the proceeding. The answer here is largely going to depend on the facts known to Commissioner Nakano at the time. So far, the only fact indicated in this slide is that Brian has provided a general statement that approval of this project will provide steady work of many union certified electricians like me. So with respect to Jay, we don't know that, or the fact isn't provided that Commissioner Nakano necessarily knows Jay's deli is located within 200 feet of the proposed site of the project. If that fact didn't come up, then she wouldn't necessarily have reason to know about the financial interest, in which case that doesn't implicate a disclosure requirement, a recusal requirement. But for example, if Jay had said, I'm located, directly across the street, then that gets into the bright line standards that we talk about in 18438.7, in which she would be presumed to have reason to know of a financial interest, in which case she would have to disclose and recuse unless she was aware of additional facts indicating that he does not, in fact, have a financial interest. With respect to Brian, I think that in this general statement, I don't know that this would amount to knowledge of a financial interest or reason to know of a financial interest. Putting it into the context of, if we received a request for advice on whether an official had a conflict under Section 87-100, and the only fact that we had was approval of the project will provide steady work, I don't know that we would be able to say that we have enough facts to determine that that official has a financial interest. I think the same would apply here, where we are going off of that same financial interest standard under Section 87-100. There just isn't enough information for the disqualification in this case. So the planning. Oh, and then, at this point, Commissioner Nakano is not necessarily disqualified from taking part in the proceeding, except for the fact that she has received the contribution from Dave. In that context, she would be required to disclose the contribution, and thereafter she would be required to either recuse herself or, if less than 30 days had passed since the time she knew about both the proceeding and knew or had reason to know about both the proceeding and the contribution, then she could potentially either return the contribution or pay it down in order to continue taking part in the proceeding. Sorry.
I think I may, if it's okay, Mr. Chair. Since I do have a couple questions that are right here in the now on this particular one. And first for Commissioner Nakano, which feels unusual to set her aside and focus the spotlight on her. But I'd like to talk about the know or reason to know. And I've written down some of the phrases you've used. There's other facts that she might know. And if she's going to reasonably know, which is language that we have. The fact I'd like to find out is if it's covered in the news. When Dave, the developer, did the application or before it comes forward, there's some news coverage or social media coverage. Now, it could be from a neighborhood group It could be from Jay's Sandwich Shop Association, if I really want to run with this. And can you comment here on what role, either what assumptions are being made about the duty that an elected official has, or a candidate in this case, has to look at the news and be aware of the news affecting their community? Because I imagine that's an advice letter we're going to get a lot on, unless we do have very clear language, and we've been talking about that. So that's my first question, is the news coverage.
Yeah, I mean, I do think that it probably, I think you're correct that we would receive advice letters on this, but I think that in some ways it's necessarily a fact-specific determination. I think that there are probably too many variables when you consider the different types of boards or agencies or different sizes of jurisdictions in order to presume knowledge or a reason to know based off of you know some sort of media coverage. One more variable would be the size of the reach of that media organization. I think that it could also get into some difficulties in terms of implementing that from an enforcement perspective. But the standard that we have drafted has takes into account the relevant facts known to the officer at the time. So I think that they're, again, going back to the case by case approach, I think we would just have to look at what was reasonable in this instance. So if this is a small jurisdiction with a local paper that everyone is known to read, that the council member has cited to in prior public meetings or something like that, I think that in that instance there's the argument can be made that they had reason to know about the coverage. Whereas if it's some sort of self-published material that wasn't necessarily that the official wasn't necessarily aware of, then I don't think that we would say that they had reason to know in that instance. But I think because of all of those variables, it would be difficult to pin down a specific provision relating to media coverage.
Yeah, it's very, all these are going to be difficult, but that's been one of the ones I've been grappling with the most, because of course a local council member, school board member, whoever, can be just voracious news readers, but they'll follow on social media a big page that is very active on an issue. Maybe it's cell towers or something else. And we don't have a presumption, I think is important to note, but usually I don't like to identify problems without coming up with potential solutions, but I appreciate you addressing that one. That was my primary one for this particular fact pattern, because you've addressed so much more. It is what they're going to be presumed to know or assumed. It's going to be very fact intensive. So that's on that one, news coverage.
Yeah, so the question about news coverage goes to knowledge that would establish when an official knew something was pending before them, right?
Right.
And as I read the regulations, and tell me if I'm reading them incorrectly, the time under our regulations, the latest time that a public official could become aware of something that is before them, something that is pending, would be when that matter is included on a published agenda for that official's agency, right?
Right.
So the news coverage, so in a sense, there is a presumption that it's no later than that date we are charging you with knowledge that there's a proceeding pending before you. The only question is, did you have knowledge earlier? Were there other facts that gave rise to you potentially having knowledge sooner than that point? Is that a correct understanding of how the regs would work in the real life?
Right.
All right. Appreciate that. I want to go back in this portion of the hypothetical when you talked about Dave, who made those contributions, and because the contributions were made after the application was filed, he didn't, under our regulations as they're currently drafted, he wasn't going, he didn't have to disclose the contribution because he hadn't made it yet as part of the application, but he does have to disclose it within 30 days. So my first question is, what form of disclosure does that come in? Because as I read the statute, the disclosure has to be made as part of the proceeding. But the proceeding hasn't occurred yet, but we're saying you have to do this within 30 days. So what is the form of that disclosure at that point?
I don't think that our regulations specify that beyond putting it into the agency's official records. I'm not sure if we had considered specifying a particular form that needs to be submitted, or whether written notice to the agency in general would suffice. But that's something that we can look into for adding to the regulations, Regulation 18438.8.
I asked the question because I'm curious, and the fact pattern prompted the question in my mind. I'm not necessarily suggesting that we try and come up with an exhaustive list of every type of form that we would find acceptable, but I am curious, just in general, were we thinking like a letter from Dave to the city disclosing the contribution? If that's kind of what we were thinking, generically, not trying to pin you down, just
No, yeah, I agree. I think that essentially it would have to be just something that can be pointed to as evidence that they made the disclosure. So I don't think that it would suffice, for example, to essentially just call, unless there was some indication that the agency had a policy of making a note and retaining the fact of a disclosure as part of their office records. I think that generally we would be looking at written disclosures via letter or email, but again, we hadn't specified it to that degree in the regulation.
Right. So when Dave shows up and testifies at the Planning Commission, does he have a separate obligation to announce it prior to delivering his testimony on that date?
Having already made the disclosure in another form?
Yes.
No.
Okay. So now let me ask you this. The 30-day requirement to disclose.
Right.
Setting aside, I personally think that's good. I think there should be a short timeline. But where is that in the statute? Like, is that 30-day time frame in the statute, or is that something that we're imposing solely by virtue of regulation?
It's by virtue of regulation.
All right. And then secondly, the statute requires the disclosure. Sorry, I want to make sure I get the language right. But it is party to a proceeding. Yeah, as part of the proceeding. So they shall disclose on the record of the proceeding a contribution. And so my question is, let's assume that we stick with this 30-day time frame. How do you then link the disclosure that's come in through a letter, right, before the actual proceeding, before the Planning Commission, then is disclosed on the record at the Planning Commission, which is, I think, what the statute contemplates. So what's the mechanism for that?
I'm sorry, could you repeat that?
Sure.
Les?
So the statute talks about making a disclosure on the record of a proceeding.
Yeah.
So, and in this example, there's a Planning Commission meeting at which the person who made the contribution, who's a party, is testifying. They have already, under our regulations, sent a letter disclosing their contribution. And when I asked you, if they show up at the Planning Commission meeting to testify, do they have to disclose it again? And I think your initial response was no, because they had already made the disclosure. And so my question is, how does that square up with the statute that requires a disclosure on the record of the proceeding?
I suppose in drafting the regulations, we were interpreting proceeding to include more than just the actual meeting itself, but the general ongoing process, in which case I would think that the disclosure beforehand would suffice. Well,
I think to the extent that that would accomplish having evidence of the contribution included in the record, big picture terms, the record of the proceeding, I think I can agree with that. I'm wondering though, if the purpose of that statutory provision was to make it clear to the public. And so if somebody sent in a letter within 30 days, that was 6 months before the proceeding actually takes place, unless that letter disclosing the contribution was required to be included in the agenda item, the public wouldn't know about it.
I see.
Which would frustrate, I think, the transparency goal of the statute. And maybe I'm wrong about that, but as I'm thinking about it, I think there's work maybe to be done there.
Okay.
I agree. A couple of points come to mind. The first is if there's a direct workaround, which is that it's just disclosed at that proceeding, and that even the staff do this, we have received the following letters or notifications prior to this in-person or whatever official proceeding, and whose responsibility that is. Is it the city clerk that says boom, 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 boom? Is it Dave coming and saying, by the way, 6 months ago, I submitted a letter? So that's one issue that would be dealt with as we look at this. The other is what it says about the 30-day rule that we are proposing, or that this regulations are proposing, that this is focused on an in-person proceeding as opposed to a written notification way earlier and during a 30-day period. Is there a statutory basis for us writing that provision into the regulations, or is what the chair has identified, maybe call that into question or contradict in any way and go beyond what we can do in regulation?
Well, I would
But
just
I made it more complicated.
No, I would just briefly return to, in the instance where the person has already disclosed, or the party has already disclosed, say via letter beforehand, you still have the disclosure requirement by the officer at the proceeding. So I don't know that the public is necessarily going to be unaware of it, because the officer also has that duty. And then going beyond that, with respect to the statutory basis, the statutory language doesn't expressly state that the return has to be made prior to participation in the proceeding, just that it be made within that 30-day window. But even beyond that, when we were proposing the 2 working day window, I don't think that this would be, or I think that this would be permissible as essentially by virtue of regulation, because it wouldn't be, it would, go towards implementing Section 84308, but it also wouldn't it wouldn't be contrary to the legislative intent, given that, the 30-day window for return in the statute indicates that the legislature did intend for officers to have an opportunity to provide or to return a contribution in order to take part in a proceeding. So in the instance that we had initially considered, where, for example, you have learned of a contribution either during or just before a proceeding, I think that the legislative intent of affording officers that opportunity to return would be frustrated by not having sort of a circumstance in which they could make that return, or essentially have to, in every case, postpone a proceeding in order to make that return.
This is Dave Bainbridge. I just would note, overall, I think we're talking about a similar issue here in a couple different contexts. One is where we're talking about what's the form of the notice, and then this more recent discussion. A lot of this is going to be up to the different agencies to figure out how to do. They have to operate. There's so many different agencies this is going to affect. They operate in different ways. So I think in drafting our regulations, we tried not to be so specific that we're saying the notice needs to be like this. It needs to be put here. we're trying to give them some ability to comply with these requirements within how they operate. And so that's sort of the struggle that we're working with in providing these regulations. So I think it's something to keep in mind is we could be really specific, but then we could have an agency come back to us and say that doesn't work with the way we operate. So we want to leave it fairly broad. I think there's some onus necessarily under the statute for the agencies then to have to come up with a process to disclose. Like you're mentioning, the proceeding has started. They have this disclosure. In a lot of ways, it's up to the agency to take that disclosure and put it forward to the public if it isn't made at the meeting itself.
So, but today, I'm kind of processing what you're saying, but I'm also trying to make sure I understand. Today, our position is that developer Dave in the hypo could have sent in the letter 5 months before the meeting, then testifies at the meeting and has no additional obligation to state the contribution during his testimony. But as you point out, the council member who received the contribution would have a separate obligation to disclose that on the record. Is that right?
That was my understanding of the statutory and requirements and how we would be applying it under 18.438.8.
Okay. It actually now gives me an opportunity to ask another question I had for you. And that is, so suppose Dave makes the contribution when he makes it and sends in the letter within 30 days. But then, 6 months passes and then the planning commission meeting occurs. And before the planning commission, Commissioner Nakano pays down that contribution, returns an amount so that it's now below the $250 threshold. Does anybody have an obligation to disclose the contribution at that point after Commissioner Nakano has paid it down below $250?
And sorry, did you specify when she paid it down after
Before the commission? Well, within the statutory time frame to do that.
Well, so
because she gets 30 days after knowing about the proceeding to pay it down.
Right. So I think in the situation that you've identified, there would still be a duty for Dave to disclose, assuming that it was not paid down within that 30-day time frame, because after he makes that contribution, he has 30 days in which he has to report the contribution. So at that point, if it's still, say, $800 contribution and 30 days passed, he's violated the act by not disclosing that. However, if Commissioner Nakano was to pay it down prior to the meeting, she would not have a duty under 84308 or our regulations to disclose a contribution under $250 in the same way she wouldn't have a duty to disclose any other contribution under $250.
Right. But the letter from Dave that he made initially disclosing the contribution would remain part of the record?
I mean,
I'm just asking.
Our regulations don't address that, but I think that as just sort of a California record keeping sort of thing, it would be part of the official record.
All right. What
can I real quick? I want to butt in here.
Develop
before we're too sure on that one.
Yeah.
Hey, no name calling here. I want to look at when contributions are received under the Act in other contexts, because I think we would consider a contribution received even if there was a return of the contribution later on. There's certain contexts where a contribution is not considered received if it's returned within a certain amount of time, the reg we're working on right now. But before we commit to that answer, I'd like to look at it more closely, because I think to be consistent with the rest of the Act, we want to say potentially that was received and then returned. And maybe that should be how the disclosure goes, but we'll put that down as a question to look into more.
Okay, that's great. I think that's a really good idea. So as we were kind of alluding to, I think I have a broader question, which is, what is our agency's view on the obligations right, on the part of public officials and perhaps the local government staffs to inquire when somebody stands up and testifies at a meeting about whether or not they've made a contribution or have a financial interest. It's like setting aside the party, but a participant, right? What is our agency's expectation, if you will, for public officials and their staff? Do we expect them to start asking people? And if they don't, do we consider that below the standard that we would expect? Like, have we started to think about that, and what perspective can you offer on that?
Yeah, we have talked about that, and I think that the advice that we've provided so far, or information that we've provided so far, for example, in the context of the fact sheet we provided, is that there isn't essentially a proactive duty to respond to or to inquire in terms of if someone gets up at a city council meeting, the city council member isn't required to ask, and why do you care about this? But at the same time, going to having reason to know, and the facts in which an officer has reason to know, I think that there is sort of a reactive duty in terms of with the bright line standards that we're proposing. If an officer has knowledge that the deli is located 200 feet across, at that point, they should recuse themselves. But if there's additional information that comes out that indicates that this person doesn't actually have a financial interest, or if additional information is volunteered that makes it certain that they have a financial interest in some other context, then in that situation, the person would have reason to know or know of the financial interest, and the disclosure and recusal requirements would apply.
So what about, like, using the deli example, because that's a good one, right? So it's like Jay, the deli owner, shows up and starts testifying on behalf of the project, right? And he says, I own a deli across the street from the proposed site. And that's all he says. Does anybody within the jurisdiction at the planning commission, either staff or commission members themselves, have an obligation at that point to now inquire? It's like, well, how close across the street? Are you within X number of feet? Like, think about how it works
Right.
in real time.
Yeah.
Right? When he says that, do they have to stop the proceeding and start inquiring on that line? And if they don't, and then it turns out that it is a conflict because he has made a contribution, then what?
Yeah, I mean, you raise a good point, and I think that part of the difficulty is that the officer is essentially being expected to make a determination on a financial interest that's a financial interest under 87-100, which in many cases can be a complex consideration and determination. In the instance, and it's further complicated by the fact that an officer is free to ask for additional information, but the participant isn't always necessarily going to volunteer that information. So I think in instances like this where an officer knows that something is across the street, but isn't necessarily sure how wide of a street is this, then I think it's going to sort of come upon the officer to, in many cases, out of I don't know that I would say abundance of caution in the context of a deli across the street, but in some cases they will want to err on the side of recusal or attempting to inquire so that they can be certain whether the participant has no financial interest.
All right. And so in that fact pattern, though, isn't that one of the reasons that staff is proposing interpreting the statute to allow a public official to return the excess contribution after participating in the decision for that type of scenario where something may have come up during the meeting, but there isn't time or an ability to really determine whether that's disqualifying financial interest, right? So you can cure it afterwards.
Yes.
It's just in real time, there is no practical way to deal with the situation when it comes up like that.
Right. No, that's correct. And I mean, in the context of the FPPC, our advice letters are issued within 21 business days.
Right.
So in some cases, the facts are going to be complex enough that an officer isn't necessarily going to be able to be certain about the determination that they make in that limited of a window. So the 30-day return window, while allowing them to continue to participate in the proceeding, sort of allows room to further consider and, if possible, obtain additional information relating to, or that would help determine whether they need to recuse or not.
Thank you, Commissioner Baker.
This raised a question, just how different Jay's interest is from Brian's. So if Jay has a deli, and I'm going to assume it's a great deli because it's Jay, and it's across the street, however big the boulevard is, I mean, we could turn the facts into everything. Go with what is presented here. And he says, I want this to happen, be really good for my deli and all the businesses in the area. The deli 2 doors down, everything else. Have you thought about how we would, as an agency, and how an official would determine a difference between Brian, who we think is somewhat more attenuated, like I think electricians generally are going to get better jobs out of this, and Jay, where I think it's going to stimulate the economy around the development, and therefore I, as a business in the area, feel I'm likely to do well. Both are somewhat speculative, but how much have you factored that into both the regulations and their practical application? It's hard to do. I know you're doing a great job.
So, I mean, I think it goes towards a couple things. Is that with respect to distinguishing them, again, it's just going to be like a fact specific situation where, in large part, related to the information that is made available to the officer. But that is also sort of the reason, or one of the primary reasons that we've included these bright line standards in the proposed regulation, is that there are certain circumstances in which, through our experience in drafting advice letters and providing advice or trainings and things on conflicts of interest, that these are situations in which financial interest is essentially very, very likely, where the officer or where the participant has property within 500 feet, or where they have a business relationship with the applicant that may result in additional services provided to the applicant. So I think that in the subtext of, or with respect to subdivision A2, we're trying to at least provide some additional guidance to officers in terms of, kind of highlighting for them, there are many instances in which you might have facts that establish reason to know of a financial interest. These are some of the most common and most obvious ones. But with respect to a situation like Jay versus Brian, it's just going to come down to what information is known or available to the officer.
I mean, I suppose we are assuming that the legislature is aware of our prior advice and these rules about 200 feet and otherwise. I guess there's probably a presumption in there, although the reality is I'm not sure every 120 members, when they vote on something, do know that. I mean, I always read the bill, but I may not have always known it. It's a problem with discerning legislative intent, but...
And on that point, real quick, could I just mention
please.
that participant being defined in the statute refers to the conflicts statute. So I think that's a good indication that they're aware of that area of the law. I don't know if they know all our advice letters, but they're aware that we have a framework.
Body of law.
Yeah, exactly.
And an implied duty on officers to have some understanding of financial interests under Section 87-100. And as we mentioned in the memo, staff plans on creating additional educational materials and providing training on it as well, because it will probably be necessary.
Yeah, great, thank you.
All right, go ahead.
Okay. Let's see. So, sorry, did I skip one? Or July.
Yeah, we're right for number 2.
Okay. In September 2023, the Sacramento Bee publishes an opinion article written by Dave, which highlights what he sees as the potential economic and other benefits of his proposed project. The opinion article notes that the project is currently pending before the Planning Commission and will require City Council approval to proceed. On November 15th, 2023, the Planning Commission approves Dave's application. Dave, Jay, and Brian all testify at the Planning Commission meeting in support of the project. So most of what is covered in this slide has kind of already been discussed in terms of circumstances in which a media report might create reason to know about a proceeding. And for example, with Councilmember West, who I believe is the council member who has received a contribution in the year 2023, this would kind of go towards whether she has reason to know about the proceeding. If there were facts indicating that this is an article that she should have been aware of or was aware of, then we would use this, or this could be evidence of the time at which she knew about the proceeding. With respect to the November 15th, 2023 Planning Commission approval, it doesn't say whether Commissioner Nakano took part in the proceeding, but again, whether she was able to take part in the proceeding or not would depend on whether she had, one, established whether Jay and Brian had financial interests and was able to either return or was able to return the contributions, or if she, and it would depend on whether she recused herself or was able to return the contribution that she received from Dave. And I think in large part we've already discussed those, but if you have any questions.
So with respect to Councilmember West,
Mhm.
you mentioned, the newspaper article could give rise to facts under which you could legally determine that she had knowledge of the proceedings sooner than when the application appeared on the agenda for the council.
Right.
And so I'm just curious, have we thought about what those facts would be like in the context of something like a newspaper article, right? I mean, if she has a subscription to the Sacramento Bee,
Right.
what is it that we would use to tie earlier knowledge to something like when something's in the newspaper?
I think that the more obvious scenario in which you could point to as evidence of knowledge or reason to know is, for example, when an agency receives emails each day from, that compile all of the articles in which that agency is mentioned. In that instance, if we were able to see that this city council has a history of doing this, and this city council member received an email about this proceeding, that could go as evidence of having reason to know. I think that would be at least easier to prove than in the instance where someone has a subscription to the newspaper, whether they in fact read or had a pattern of reading it. But
Does it make a difference in your mind whether or not that is something set up where like the agency sends out news clips to its members as opposed to an individual member having like Google News alerts set up where they get information? So they've privately set it up, right?
right.
Versus the agency does it in the normal course. Is that a distinction that matters for our purposes?
I don't know that it would be a distinction that matters for purposes of substantively whether they have reason to know. I think it would be more so going towards enforcement and acquiring that evidence. But yeah.
No, I think having not seen this before, I think this kind of was addressed in my prior point. So I appreciate we've got to grounded it in a fact specific. Thanks.
All right, let's move on.
All right, so Dave's project is listed as an action item on the agenda for the City Council's December 15th, 2023 meeting. At the start of the December 15th, 2023 City Council meeting, the City Manager announces that Dave's project is being pulled from the agenda to give staff additional time to review the application and recommendation from the Planning Commission. On December 16th, Dave attends a fundraiser for a group that is proposing a city initiative measure that they believe would make it easier to approve affordable housing projects. Councilmember Hahn is one of the speakers at the fundraiser. She tells the audience she strongly supports the initiative measure and asks the people in attendance to make campaign contributions to the committee formed to support the measure. Dave tells Councilmember Hahn that he will contribute $5,000 to the committee. So the first portion of this, in terms of there being an item on the agenda for the December 15th, 2023 meeting, that goes towards, as we talked earlier about when the proceeding is pending. Under, I believe, option 1 and option 3, the city council member would have, or a proceeding would be pending with respect to an officer, either when it was before them or when they knew or had reason, or it was reasonably foreseeable that it would come before them and they knew or had reason to know about the proceeding. So in this situation, even if we assume, for example, that Councilmember West didn't see the September Sacramento Bee article, we know that at this point they've received the agenda, or the agenda has been published, indicating that Dave is a party coming before them. So at the latest, under any of the options, this is when the proceeding is pending with respect to those officers. And then further, with respect to Councilmember Hahn, we had talked about how the 2022 contribution that Dave made was, we could essentially disregard for purposes of section 84308 because that was made prior to SB 1439 coming into effect. Here, however, Councilmember Hahn, this raises issues of whether Councilmember Hahn has solicited a contribution and whether Dave has made an impermissible contribution. We know that, again, at the very latest, the proceeding was pending with respect to Dave at the latest when the decision came before them. Or it could have been as early as when the application was first filed. So that goes towards whether Dave's $5,500 or $5,000 contribution was permissible, and likely was not permissible in this case. And it also goes towards whether Councilmember Hahn violated section 84308 in accepting the contribution after the proceeding was pending, given that she was already aware of Dave's, already aware of Dave being a party in the proceeding based on the agenda she received on for the December 15th meeting. So we're were there any questions?
Well, yeah, you said Councilmember Hahn accepted the contribution, but I think the
Okay,
fact pattern is she's speaking at a fundraiser,
Right,
and I will use the term soliciting other people to make contributions.
Right.
And Dave does that and tells her about it. So is her problem under the statute is whether or not she is soliciting or directing a contribution from somebody who is a party to something that she has pending before her, right?
right.
Okay.
If may also add, and we're talking about this is a committee formed to support the measure, not her own campaign committee, which gives you an opportunity to sort of discuss that
Right.
language. I just also want to say, maybe she hasn't broken the law in other ways. Very dicey to be at a fundraiser and say, I will vote this way if you give money that way. Not something I would recommend people generally do. I'll leave that to Dave, the general counsel, and our advice line.
Yeah.
There's this may have skirted, not as a violation as it is, but for anybody who's watching, I don't encourage exactly that kind of behavior. Is that fair? Shane?
Like, I'm not sure that that's part of the hypothetical.
Well, yeah, I just don't want it to be overread. This is a very specific hypothetical, but
Yes.
when I read this, I thought, oh, that's, just proceed with caution.
Right, and the soliciting provisions under Regulation 18438.6, under that standard, the officer solicits a contribution only if they know or have reason to know that the person being solicited for the contribution is a party or agent of a party or participant or agent of a participant. And the officer requests, one of the provisions is the officer requests a contribution for any campaign or committee, including those not controlled by the officer. So in the first part of that fundraiser hypothetical, we don't know that Councilmember Hahn is necessarily aware that Dave is present in is attending the fundraiser, but at the point at which Dave comes up to her and indicates that he is going to, then it definitely moves the needle from potentially soliciting to very likely or in fact soliciting Dave for a contribution.
Admittedly, I was drawing a little bit outside the lines, but just for anybody who might be casually watching this, I just think it's good advice.
Well, and the one thing about this part of the hypothetical, you could change the fact. So instead of having the initiative measure being something related to or similar to the project that Dave's getting proposed, I mean, this could be anything, right? It could be online gambling, like whatever the recent statewide ballot measures are. So something totally attenuated from what Dave has before council, and it still is going to trigger an inquiry under our statute. So
Right.
I think it's important that public officials understand that as one consequence of the new law.
Yep. Okay, so Dave's application is considered by the City Council at its January 15th, 2024 meeting. Dave, Jay, and Brian again testify in support of his application. Chris, the owner of an upscale restaurant located next door to the proposed project site, testifies in opposition to Dave's application. While Chris has not made any monetary contribution to any member of the City Council, he allowed Councilmember West to hold a holiday party for her staff at his restaurant free of charge in December 2023. The fair market value of Councilmember West's use of the restaurant is approximately $1,000. Councilmember West reported this on her campaign finance filings as a non-monetary contribution from Chris. At the conclusion of the meeting, the City Council unanimously approves Dave's application. So this goes into a few different things. First, whether Councilmember West and Councilmember Hahn took part in this proceeding, and it says that the City Council unanimously approved it. So assuming that they did in fact take part in the proceeding, they have likely violated Section 84308. Councilmember West, at the point at which she, in fact, at the December 15th meeting, would have been required to recuse herself or disclose and either recuse or, depending on the circumstances, if she's able to return, the contribution from Dave, and I believe also from I'd have to look back at if Brian had made a contribution in 2023, but given that Brian didn't participate, anyway, she would have had to either disclose or recuse herself based on Dave's prior contribution, beginning at the December meeting. Here, it seems like she did not do that and instead continued to take part in the proceeding. So it appears that she violated section 84308. With respect to the participation by, and the same would be with respect to Councilmember Hahn, who only recently solicited the contribution from Dave. She would have been required to recuse under section 84, or disclose and recuse under section 84308. With respect to Brian and Jay's participation, again, it would just go towards what information was available to council members West and Hahn. I mean, I know that they would have been required to recuse just based on Dave, but with respect to disclosure of any contributions made by Brian and Jay to either of those council members, it would come down to what the content of their participation amounted to. And then lastly, with respect to Chris, we would still consider a non-monetary contribution to be a contribution for purposes of section 84308. So Councilmember West would also be required to disclose and recuse or return or pay down the $1,000 contribution from Chris. And Chris would also have been required to disclose that that contribution if he had not already done so. And so I think that covers most of the hypothetical, but if you either of you have any remaining questions.
I want to make sure I understand. Did you say that Councilmember Hahn did have to disclose on the record the $5,000 contribution that she solicited and Dave made to the ballot measure committee?
Oh, I was thinking in the context of having actually received the contribution, which the hypothetical does not specify, so points off my grade. In that context, the act doesn't specify that disclosure of solicitation is required, and our regulations do not require that either.
Okay. But under, as you explained in number 3, that action would have been unlawful by councilperson Hahn because she would have been charged with knowledge of Dave as a party by virtue of him appearing on the agenda the day before.
Yeah.
Right? Now, let me ask you this. Could Councilmember Hahn have worked with the ballot measure committee to return that contribution and thereby cure that violation? Because we know public officials can, when they receive a contribution, participate in a decision and within 30 days from the date that they have knowledge of the proceeding, return it and cure it and not be in violation. Is the same true with respect to the solicitation or direction of a contribution to somebody else?
I don't think that I think that in that instance, the act of the solicitation is the violation, which is separate from receipt of the contribution. So I don't think that there's a cure for the solicitation.
Okay. All right. I just wanted to clarify that. Okay. Thank you. Any questions for?
Not on this. I think you preempted him, so thank you.
Great job.
Thank you.
That was a lot.
It's
I do
nice
have others
law
not
school
related to this.
reminder.
So do I. Why don't
Okay.
you start and
Yeah.
we'll go through.
And mine is these are more for points of clarification. So
Yeah.
we focused a good bit on financial interest because that's what the statute says.
Right.
I'm mindful that there are also situations where parties and participants may come before councils and other bodies that this statute would apply to, where their interest financial is even more attenuated, but it's maybe aesthetic or health. And the example that keeps coming to mind for me is what I read about in the paper, and this, I'm not targeting cell companies, but any more than we targeted delis a moment ago. But cell towers in a community, sometimes homeowners who give to planning commissions and candidates and council members, their beef with a cell tower is its look, and they think maybe possible health effects. Perhaps someone, including this agency or someone who files a complaint, could say there's a financial interest because it could affect the value of your home. But let's say that some of these scenarios have been changed because the issue isn't a development. It's building something that it's less clear if there's a direct financial interest, but the people who are commenting in proceedings are really focused on how it looks, maybe other not in my backyard scenarios that aren't as explicitly financial. Do you see any scenario under which this statute may apply? Or these regulations, or the statute, yeah.
I mean, I hate to say it depends, but it kind of does, because whether the participant has a financial interest is based on section 87-100, which we clarify with our regulations. So
we have a lot of history with what is a financial interest.
Right. Yeah. So, for example, someone who has a month-to-month lease in an apartment isn't, under the Act and our regulations, considered to have a real property interest for purposes of the Act. So when they come to a city council meeting or wherever and complain about a cell tower, it's a different, we don't consider them as having a financial interest under the Act, even if they live directly across the street, whereas someone who lives 400 feet away, but their view might be affected by the cell tower, then we say that they do have a financial interest. So it does have to tie to one of the standards in which it's reasonably foreseeable that the decision will have a material financial impact on one of their interests. So it's just going to come down to personal finances, sources of effect on source of income, business entity interests, real property interests, that sort of thing.
And I alluded earlier as I encouraged us to take a one-time outreach to some other associations, school boundaries. Again, this is an area that can cause a great amount of attention, certainly a great amount of feelings among parents and families and neighborhoods, and for a variety of reasons, having to trek across town versus something that's just a few blocks away, that are not necessarily financial. And so I wanted to keep that one in mind. I think it's important that we know there could be an attenuated financial, and we don't want to go outside of what the statute has very explicitly said. The second one is an issue I think I raised in February. I don't know how artfully, but I've been thinking about it. I want to get a little more specific. This has to go to the whole notice and disclosure and what is an elected officer aware of, and want to know how this has played into your deliberations since February. In some cultures, the name of the donor, the person's legal name is very different than what they're known for. In my district, for example, there were many folks from Asia who used a more anglicized name instead of what perhaps their given name is. And the only time you see the given name is in the campaign contribution and otherwise. And that's a very specific point, but I know that there will be districts and communities where that's very real, both for notice to the officer and even to the public. how, if at all, did you factor in that feedback from February that how an officer is supposed to have a heads up if someone gave a contribution and they're coming before us? They may be using the name Jason or Nancy. But their contribution doesn't say that at all. Their disclosures. Has that factored at all into this? I know it's a very specific fact pattern, but it's not an infrequent one.
I think that it's not expressly addressed in the regulations, but I do think that it is factored into the fact that the disclosure requirement applies to both the party and the officer. So at the point at which the party has either made the disclosure with their initial application or within 30 days of making that contribution, in the majority of cases, the officer is going to have an opportunity to look into, whether Jason made that contribution, and if they don't see that, then there's in many cases going to be an opportunity for follow up to look into the contribution and see where the discrepancy lies, and that does sort of imply a duty on the part of the officer who also has to make that disclosure to ensure that the facts that they're disclosing are accurate. With participants, I think it's a little bit more difficult because in that context, someone might, regardless of what option the commission chooses for the point at which a proceeding is pending, or it's a little bit more difficult in the context of a participant because it could occur in the middle of a proceeding. So I'm not sure that there is an artful solution other than the fact that the 30-day window would provide the opportunity, or the 30-day return window would provide the officer with an opportunity to return the contribution after already taking part in it. But we could look into adding to 18438.8, which relates to the disclosure. We could just add something that effectively says, in making a disclosure, a party is required to list either their legal name or the name under which a contribution was made. And that would, at least with respect to parties, hopefully address some of that. Some of the just difficulty with 84308 is the fact that participants aren't required to disclose their contributions. So it's hard to cross-reference in that.
Right.
Yes.
And again, I don't want to single out any particular ancestry. It can be anywhere across the world and any heritage, but that it's not uncommon for people. I mean, they have doing business as for corporations. But I don't know that my feedback right now isn't to try to get even more specific about a requirement. Just I myself want to digest that, but wondered how you factored that in from February. I don't want to preempt the chair from commenting on that. If you were, I have two more points that are unrelated.
Yeah, I was
Dave
just
the
gonna
developer.
saw it in my eyes. I was just gonna say I think that question gets to this issue that we had brought up of, do you want to assume that anything that's reported on a campaign statement is known by the official, or do you want to look at more of an actual knowledge type standard? Because if you're holding them to what's on the campaign statement and the campaign statement requires someone's actual name, I think it's more of an issue. If you're holding them to a knowledge standard and they say, yeah, I know that guy is Jason. I didn't know this was his real name. I didn't know he was one of my contributors. Then you don't have actual knowledge. So I think if it's a concern, you lean more towards the actual knowledge standard as opposed to the implied knowledge based on the fact that it's on a campaign statement.
I see what you're saying. I think that's partially right. But if the participant shows up and gives their name as one thing, and the campaign report that the public official is charged with knowledge of lists a different name, And I'm not sure. I think at that point, when the participant makes the disclosure about it and the public official says, I don't see you on my list, doesn't that actually put an obligation on the public official?
Yeah, I think
That's like the reason to know standard, right?
yeah, I'd call that knowledge, or at least reason to know.
To inquire further, because they are not, the names aren't syncing up at that point.
Right.
Okay. All right.
Thank you. Hopefully two other quick ones, thank you for the deference. And this is for clarification. So there are many ways in which people in the public participate or make their speech known that are outside the type of proceedings we're thinking of. And I'm thinking of a community does not want whatever this is built, and they organize a Facebook page. They protest outside the council or planning commission meetings, but they don't necessarily go in and get their names on the records. But it's funded, organized, people are contributing to one campaign or candidate or decision maker or another. Can you address, are those, I mean, right outside the council meeting the night of the hearing, or those efforts that maybe even are tagging, specific people who are making votes, like a council member, Han or Nakano? Can you comment on how that may likely fall outside of the regulations? And these are people who have a financial interest. They're definitely getting attention, but they haven't come in and said, me too, I oppose, or I support this particular decision that day.
Yeah, I think that Section 84308 just statutorily refers more to participation in the context of within the proceeding. And we did receive a lot of comments, particularly prior to February, concerns about whether, someone getting up and simply saying, I don't like this, what is being proposed, like whether that constitutes someone who is a participant and whether that triggers the limits on their contributions. But as we've tried to explain, participant has a very, it's sort of a term of art. It has a very specific meaning, and it relates to participation in the context of the proceeding, and not general dissent.
Yeah, because this is getting more specific, where they go meet with the council member in an office or otherwise, but they don't show up at the proceeding. So I throw that out there. And then there's folks, at least in the legislature, this used to happen. They were called tweeners. They get up and testify. It's like, I don't support it. I don't oppose it. These are some problems I have with it. Here's some parts I like about it. They've weighed in on the record, and they may have given a whole bunch of money. I just want to see how we account for those two scenarios of even more specifically lobbying or advocating, but it's in a slightly different way.
Well, I should clarify that in the circumstance where someone is going to talk to an officer outside of a meeting, but is directly speaking with them, whether it's in the office or otherwise, as opposed to simply picketing outside of a government building. In the instance where it is a direct communication, we would consider that lobbying in person. And then, sorry, could you?
Tweeners.
The tweeners, although the definition of participant, like the initial definition, uses the language of support, someone who actively supports or opposes a particular decision, that phrase is in turn further defined and can be someone who otherwise acts to influence officers of the agency, or lobbies in person, or testifies in person. And within Regulation 18438.4, we wouldn't necessarily I don't think that the officer needs to make a determination that this comment is exactly, this is a supporter, or this person is in opposition, so much as whether they're trying to influence the decision. because there, like you said, there will be various parts of a proceeding or of a decision that might have varying opinions on.
Yep. And I thought that was a good improvement from where we were looking at this before. Thank you. The last one is how this may apply, if at all. I think there's an answer to that, to the behesting of payments. So if, council members are now looking at this and they're saying, I'm going to try not to be cynical, but they're saying, well, there's got to be another way for me to not have to comply with this quite the same way. And maybe I'll behest that payments go instead of to my campaign or even a committee I don't control to, a nonprofit or otherwise. Can you comment on how behesting type scenarios intersect here with these regulations in the statute?
Yeah. I don't think that the regulations specifically address the scenario of behesting a payment to a nonprofit. They are tied to contributions made to a political committee. But again, there are also the behested payment provisions of the act, which would either require reporting or limiting, depending on the circumstances. But 84308 is limited to political committees.
Thank you.
All right. One follow-up question on the it's 18438.4, and Commissioner Baker was asking you about the different categories, right? So a one-on-one meeting with the council member, like that seems pretty easy. That's
Right.
captured by the statute. Tweeners, that's a different thing. But then this idea of a group, a well-funded group, having people stand outside council chambers with signs and make or Facebook, or frankly putting out tweets, right, saying the council should approve this. Tell your friends, the public should know this, right? Under subdivision D, none of that would be included within the scope of the regulation as I read it, because those are communications made to the public,
Right.
right?
Correct.
Okay. All right. I just wanted to make clear that that's kind of the line we're drawing there between a direct communication and a more public pronouncement about
Right.
what somebody should do. All right. Going to the language of the regs itself, I had a question about 18438.3 agents. I see in subdivision A,
Mhm.
find it as, an agent, somebody who for compensation appears and communicates, right?
Mhm.
Does the compensation have to come from the party or participant to the agent? What if the compensation comes from some third party to the agent? Right? Like, suppose a party or participant wants to evade this, and so they have somebody else make the payment.
Right.
Or
Does that
they
matter
pick
for
someone
us?
who's being paid on somebody's staff already to be the volunteer.
Yeah.
Yeah.
And we don't say that it has to be from the party or participant. So I'm reading it, I would ordinarily read it broadly to mean any compensation from anyone for purposes of showing up. But how do you read it?
Yeah, I mean, I would read it that it does not require that the party be the specific person to compensate them for that reason. And then going further, it would likely be that in many instances where a third party is paying someone, to act as an agent, it could very well be that that third party is also an agent. Or is considered part of the party under 82015.5, depending on their relationship to the party or participant. But yeah, I agree that it does not require that the party be the one to compensate, as long as the person is compensated and is appearing on behalf of that party for the purpose of communicating with the agency for the purpose of influencing the proceeding.
Okay. I appreciate that clarification. I had a question for you under 18438.1. This is where we define who the public officials are that are subject to these requirements. And I want to first, under the statute, it's pretty straightforward. It just says any elected or appointed officer of an agency, period, right?
Right.
So for our definition, though, you include, I'm looking at D1, 2, 3, right? So D1 is the elected or appointees to elected positions. That's easy. 2, we say a member of a board or commission, but we're not specifying appointed. And so I'm just trying to, again, kind of tethering this to the statutory language where it's either you're elected or you're appointed. If you're either of those things, you're within the scope, period.
Right.
And so is this language serve as a member of a board or commission? I don't know, I'm just going to ask, but are there any circumstances in which somebody would be that but not elected or appointed that we're aware of? If nobody else has raised it as an area of concern, I'm fine with it. But because I think you could have written this differently. You could have just said exactly what the statute said, and that's very broad, right? This seems more specific to me. It doesn't use the word appointed, so it got me thinking, why did we do it this way?
I think that it may have been just in terms of in the context of the other subdivisions specifying all of the different circumstances. You're right that we probably could have done it. We could have included elected and appointed in a single subdivision and further specified the other contexts. But I think it was just trying to get to sort of hammer home all of the different definitions or circumstances in which a person could be an officer, with the subsection 1 trying to illustrate the more so focusing on the instance of someone who has been appointed to an elected position, 2 being the general instance. And again, there will be overlap. For example, someone serving as the head of an agency is likely, someone who has either been appointed or elected. But going towards like subsection 4, dealing with the people who aren't necessarily in those positions but are in a decision-making capacity and acting as a candidate. I think we just wanted to be sure to cover all of the various scenarios, and maybe went further than was necessary, but that was the intent.
Okay, so the intention is to have this refer to elected or appointed members of boards or commissions, is what I'm hearing you say.
Correct, yeah. Yes.
What if somebody was like, and I'm just curious now, suppose like the city manager sits as a ex officio on by virtue of some local law, on one of their boards or commissions. Is that person covered by our regulations?
I'm sorry, I'm just trying to think of all the various situations. But I believe that they would be, yes.
Okay. All right. Then my other questions, like, staff has identified at least 2 regulations where they've given us options of different, and so do we want to try and see whether we have recommendations for our colleagues next week, or would you prefer that we just have those discussions next week? Kind of like where are you at with that?
I normally would like to recommend to colleagues, but that's usually my default. I'm not sure I'm there yet, because today and going through these fact scenarios, which we got this morning, and some of my own questions is going to keep me definitely thinking over the next week. When we next deal with this is next week on the 18th. Normally I would do that, but I think in this instance myself, I'm still digesting. What are your thoughts?
No, that's fine. It's a lot of information.
It is, yeah.
Ordinarily, I think law and policy, we can use this as a way to give you clear guidance going into the commission meeting, at least on what two commissioners think. But this is very dense.
Yeah.
So I appreciate the fact that we may not be able to do that today.
Yeah. And I mean, we could. I just think there is a lot to still digest from your great answers and the questions we've started with. So I think I'll leave it at that.
So then one clarification question on 18438.7. In that regulation, you have offered options 1 and 2, but I have a note that says, or both. And so I wasn't sure if I wrote that. Is what you're saying that staff would recommend the commission adopt both as, option 1 and then at the end, or option 2, the way the regulation would read, so that essentially you could qualify under either one? Is that what you were saying?
I don't think that you necessarily need an or. I think that the first one would just specify that the fact that it's been reported isn't sufficient to establish knowledge for the officer's knowledge of the contribution. And then going forward, the fact that the contribution has been reported in combination with the fact that it's on the party is on the agenda would, for parties, establish that the officer does have knowledge in that instance.
Got it. Okay, I follow it now. Okay, I just wanted to make sure I was clear about that. All right.
Yeah.
Any more questions for?
No more. I thank you for clearly was lots of thorough work and connection. I mean, I know I put an additional request on some outreach if it can be done in a very time respectful and efficient way to a few more groups, and it's up to them if they're going to provide any input through next week when we may adopt these. So I just want to thank you for the thorough work. Yeah.
Thank you.
Yeah, excellent work. You're not quite off the hook though, because now I'm going to call for public comment. Is there any public comment on item 3? These are our proposed adoptions of regulations relating to the Levine Act.
Yes, hi, Jay Carson with Nielsen Merksmer.
Good afternoon.
Hi. I have a comment on 8438.5. It's just a relatively small recommended change. We submitted a comment letter at the IP meeting recommending this change, and the version of the regs that I just saw posted for today's meeting, I didn't see the change in place, so I wanted to highlight it again. On line 14, that's section B2, line 14 reads, the period beginning on the date the party or principal first hired the agent as either a paid employee, contractor, or consultant. Our comment at the IP meeting, and continues to be our comment today, we think that word principal is incorrect, and that line should read the date the party or participant first hired the agent. If staff did intend to use the word principal there, I'd appreciate some discussion on that, because principal is not, defined in 84308. Participant is. We've talked a lot today. You all have talked a lot today about parties and participants. So we just think that one clarifying change would be helpful to align it with the existing and the current regs and the statute. But if principal is the intended word there, I'd love to hear why.
All right, thank you, Mr. Cornwall.
I appreciate that, and appreciate reiterating the comment. I'm not sure what happened there, because I did make a change to a version of the regulation to replace it with participant. Must have gotten the versions mixed up, but I will correct that to participant. And thank you for pointing that out.
Thank you very much, and thank you all the hard work on this and for the other conforming changes that you made to the 0.5 regulation. I think cleaning up that section C was helpful as well. So thank you for your time.
Thank you. All right, any other public comment? This is item 3.
This is Sean McMorris with California Common Cause.
Good afternoon.
Hello. First, I just want to thank the commission staff for all of their hard work. I think they've been very responsive to stakeholder feedback. Really appreciate that, and also the commissioners' engagement on this matter. So it's much appreciated. We submitted another letter just this morning, but I just wanted to kind of point out some of the things that we mentioned in there regarding the competitively bid contract. We agree with the, this is for regulation 18438.2, competitive bidding. We agree with the commission's interpretation of a competitively bid contract, and it adheres to other opinion letters that or advice letters that the commission previously sent out under the Levine Act. Regarding 18438.2B, when a proceeding is pending, California Common Cause now supports either option 2 or 3, and we appreciate that the commission staff came up with option 3. We think that it's a good compromise there between the two. Regarding regulation 18438.4C1, just a minor recommendation and edit to this particular subclause. It currently states the person communicates with an employee of the agency in a manner not otherwise specified in subdivision A or B. We would request that you insert the word or officer, employee or officer, in that language to ensure that they are covered there. And for regulation 18438.5, and this is and this is regarding the deleted regulations, or from the proposed regulations, the previous iteration. Now the commission is proposing to reference section 8201.5, 15.5 in the Political Reform Act, which I think is useful, but we're also concerned that it doesn't adequately cover all of the instances that the previous language in the previous iteration of the regulation noted. For example, 820.15.5 covers contributions controlled or directed by the same individual, but the previous iteration of regulations also noted individuals who not only control an entity's contribution, but also control the entity or their agents, and contributions made by a party or participant's parent or subsidiary entity and otherwise related business entities. We think that it's much more thorough. So we're requesting that at least some of that detailed language remain in that regulation, perhaps in addition to the reference to 820.15.5. And regarding another subclause in that same regulation, because a matter could be pending longer than 12 months, we are recommending that subclause B1, A2A, add the language. Currently it states the previous 12-month period. We recommend adding "and" while a matter is pending before an agency. And then finally, on regulation 18438.7B, we now support adopting options 1 and 2 under subdivision AB as recommended by staff, and we appreciate them making that recommendation. And that's all for us. Thank you very much.
All right, thank you. Any other public comment? This is item 3. All right, hearing and seeing none. Mr. Cornwall, unless Commissioner Baker objects, I think with respect to 18438.5, the proposed changes just mentioned by Common Cause to subdivision C, could you for purposes of the meeting next week, be prepared to talk about what the differences are in activity that would be captured if we kept it the way staff is proposing versus added the additional language that Common Cause is proposing, so we, from a practical standpoint, can get an understanding of what's in and what's out under the different approaches.
And no objection to that.
Okay.
Yeah.
Right. Appreciate that. And then I would also like staff to be prepared to talk about the change Common Cause just mentioned to that same regulation with respect to the look back period, because I do note that the statute refers to in several places both when something is pending and for the 12-month period afterwards. So that proposed change seems to better maybe track the statute, but I also want staff to be able to talk to us about why they chose to take this approach. So for next week, if you could do that as well, appreciate it. All right, any other public comment on item 3? Hearing none. Commissioner Baker, anything further on item 3?
No, thank you.
Mr. Cornwall, anything from you on item 3?
Not at all.
Thank you. That
Excellent.
was awesome.
Thank you very much.
Really, like we kept you there over 2 hours.
Yeah,
That
much
was a great
appreciated.
job, Kevin.
Human break?
Yeah, let's take a 5-minute break and then we'll get to the ledge report. All right, we'll go ahead and go back on the record here. We are on item number 4. This is our legislative update, and joining us is our senior legislative counsel, Ms. Nakano. Good afternoon.
Good afternoon. All right, as a general update, many of the bills affecting the PRA have been placed on the suspense file in the appropriations committees. As a refresher, in the Assembly, bills are placed on the suspense file if they have a fiscal effect of $150,000 or more from any fund source. And in the Senate, bills are placed on the suspense file if they have a fiscal effect of $50,000 or more from the general fund or $150,000 or more from a special fund. The suspense hearing for the Senate Appropriations Committee is scheduled for May 18th. The Assembly Elections Committee has not posted the date of its suspense hearing, but it will likely be on May 17th. Today, I will provide status updates on all of the PRA bills, including their fiscal effects. Starting with the FEPC-initiated bills, AB 868 by Assemblymember Wilson relating to the Data Act. That bill is on suspense. The Commission's costs include IT costs relating to developing and maintaining the public record. SB 29 by Senator Glazer relating to the Political Reform Education Program is also on suspense. The Commission's costs include 3 positions. SB 678 by Senator Umberg relating to disclosures on online third-party posts had no significant costs and is on the Senate floor. SB 888 authored by the Senate Elections Committee, that's the bill making several changes to the PRA, is also on suspense. The Commission's costs are minor and absorbable, but the SOS has costs relating to completing the redaction workload required by the bill. Any questions on Commission-initiated bills before I move on to other Commission-related bills?
Nope.
Okay. AB 37 by Assemblymember Bonta relating to using campaign funds for security had no significant costs. That bill is on the Assembly floor. The Commission had questions about whether the author would be open to a reimbursement provision to require that individuals must pay reimbursement if they want to retain a security system installed in their home after the end of a campaign, after an elected officer leaves office, or after a staff person is no longer in employment with the campaign or office. The author staff responded that the author is open to requiring that candidates and elected officers must pay reimbursement if they want to retain this equipment. However, the author is not interested in requiring the same for staff. There was also a question about what is the norm under the PRA for valuing equipment in order to purchase it from a committee. The norm is to pay the committee the fair market value of that equipment. The next bill is...
Can I ask
yes.
a question?
Yes.
I'm curious now, you got me thinking. So suppose that the bill is amended to require reimbursement by the candidate, right, or the office holder, but not the staff members. When the staff members leave service and take with them the value of that security system, is that reportable as like a gift? Like, is that in any way reportable is really my question. I'm just curious.
I need to do a little more research into that. My first thought is that it might be created as an exception to the gift rules, but I need to look more into that, and I can get back to you next week.
Okay, I appreciate that.
Question. So since that one is on the floor and House of Origin will be coming like in a couple weeks or a few more weeks, I wonder if our commission colleagues would want to weigh on this for sure, but if now is the time to request at least reimbursement of the elected official, and leave it open with the author to determine what we may do with respect to the value of something to staff. Again, these are funds that are not taxpayer funds, but they're funds given in trust to the candidate that then someone is going to get a benefit that may have been very necessary but is never returned back. So I still want to think about what we might do with respect to staff. I'm also mindful that they don't control the campaign finances and have different budgets. So I'd like to keep that one open for further discussion, but if now is an appropriate time to request that the author make those changes, because they can take amendments before, the House of Origin, they can do a couple of readings. I believe, if I'm remembering procedure correctly, they don't have to do it after. Can you advise on that? The advising on how they would be able to take the amendments, and now is an appropriate time to weigh in on this particular provision.
Yeah, I do think it's an appropriate time for the commission to weigh in. When they decide to take those amendments, I'm not sure. They could take them while they're in committee. They could take them before they leave the House of Origin. I think that would be up to them at this point.
So if we, as a commission, voted next week to support if amended, and we articulated the amendments being creating a reimbursement mechanism for the officials, that would, I think, accomplish the goal of identifying the amendments we're seeking and otherwise supporting the bill, right?
Yeah, I think I would be more inclined to request the amendments and then have the support if amended to keep that pending staff discussion open. I would separate those two items because I want to. And I want to keep the door open to further conversation. Since they haven't asked us to take a position on it, I feel a little bit more leeway, and certainly we can get to support if amended, especially if they've made these amendments and we're leaving the door open. I would definitely want to do it before it leaves the assembly if at all possible, because the momentum that, it'll be said, hey, it came out of the assembly with this, this many votes and nothing else, and it's hard to pull it back. The sooner you intervene in the House, the better. What do you think about that option?
So then I think that's perfectly fine. So the action item from Ms. Nakano would be to craft language to give to the author that accomplishes the reimbursement requirement for the officials.
Yeah, or their family members, because again, that can also be other family members, and it's the staff that we want to leave for more discussion.
Okay.
Sure. Yeah, thank you.
Okay, if there are no further questions on that one, I'll move on to AB 83. This is by Assemblymember Lee relating to foreign influenced business entities. That bill is on suspense. Both the FPPC and the SOS have costs on this one. SOS has significant costs associated with incorporating this filing into the new CalAccess replacement system, and they also have additional staffing needs. AB 270, also by Assemblymember Lee, relating to public financing of campaigns, that is on suspense. SOS has costs relating to the cost of placing the measure on the ballot. AB 334 by Assemblymember Rubio, codifying Section 1090 advice relating to independent contractors, had no significant costs and passed in the Appropriations Committee. That bill's on the Assembly floor. SB 24 by Senator Umberg, also relating to public financing of campaigns, is on suspense. As with AB 270, SOS would have costs associated with placing the measure on the ballot. SB 248 by Senator Newman, relating to a new candidate experience disclosure, is also on suspense. SOS has costs on this one relating to accepting and processing the new disclosure statement and other administrative costs. SB 328 by Senator Dodd, extending the contribution limits to all local elective officers, is on suspense. The Commission's costs are for anticipated workload increase, as the bill would extend the PRA's contribution limits to potentially more than 4,000 new local government agencies. SB 409 by Senator Newman, creating a pilot program for candidate ballot pamphlet video statements, is on suspense. SOS would have costs associated with creating and administering the new candidate video statement program. SB 681 by Senator Allen, decreasing the number of days that a PRA bill must be in print before final voting, had no significant costs. That bill is on the Senate floor. SB 724 by Senator Glazer, requiring reporting of paid communications that identify elected state officers, is on suspense. Both the Commission and the SOS have costs on this one. SOS's costs are for incorporating the form into the build of the new CalAccess replacement system and ongoing costs related to increased staff workload.
Yeah, go for it.
I just question about this one. I wanted to reiterate, I think it's great, but am I reading this correctly that it's just state officers? Does this not apply at all to like local councils? I guess not. It only applies to state officers.
That's correct. The bill is only written to apply to elected state officers.
Was that the original? Do you recall if that was the original way it was introduced?
Yes, it is.
Certainly, it's within the author's purview to limit it to just state officers. I'd be. This isn't a time-sensitive question, but curious why they wouldn't expand that to local. There's got to be lots of reasons, and wonder if that's something that is on consideration for them. Thank you.
Okay, moving on to SB 858 by Senator Nilo. This is the bill that would transfer the duty to write ballot titles and summaries from the AG's office to the LAO. That bill is also on suspense. On this one, LAO would have increased costs relating to the additional administrative workload. Last, SB 573 by Senator Wahab relating to a one-year ban on lobbying activity for certain legislative committee consultants is now a 2-year bill. So the bill will not be moving forward this year, but may be taken back up early next year. And that concludes my update, but happy to answer any questions.
Any other questions for Ms. Nakano?
No, thank you.
All right, thank you, Ms. Nakano. Any public comment on item 4, Ms. Nakano's legislative report? Hearing and seeing none, thank you, and see you next week. All right, last but not least, do we have any discussion items for the June 2023 committee meeting? This is item 5. Commissioner Baker, anything in particular?
Not at this time. I think we got enough to bite off before then, so thank you. I know that around that time, we're going to be getting close to both when the budget passes, and sometimes there's trailer bills that change policies, and we'll see what makes it out of House of Origin, but I'm sure those will already be covered. Thank you.
All right. All right, that brings us to the end of our agenda. Do we have a motion to adjourn?
So moved.
Second, Ms. Contreras. Call the roll, please.
Commissioner Baker,
Aye.
Chair Matich.
Aye. So the motion passes.
Passes.
All right, we are adjourned. Thank you, everyone. Good job.